All right, I will call this meeting of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores?
Present.
Senator Orenshaw? Senator Lang? Senator Wynn? Senator Hansen? Senator Krasner? Senator Ellison? Chair Scheibel?
Here, thank you. Please mark Senator Ellison absent, excused. Please mark Senator Lang present when she gets here. I know that she's presenting a bill in another committee. Just another reminder that we have entered that time of the session when I know all of our members have to come and go to make other presentations, even to catch up on meetings and other important business. So please don't take it as a sign of disrespect if you see members coming and going throughout the meetings for the next couple of weeks. I assure you that they are keeping up to speed with all of the bills, and we'll accommodate schedules as we need to. So with that, we just have, I also wanted to welcome our folks here from the Nevada Justice Association. I understand you have your leadership cohort in attendance, and so welcome to the Nevada Legislature. And we have one bill on our agenda for today. I will go ahead and open up the hearing on that bill, SB 258.
Thank you, Chair Scheibel and members of the Committee of Judiciary. I'm Rochelle Wynn. I represent Senate District 3, and I'm presenting Senate Bill 258. I should say I'm not presenting Senate Bill 258, but I will turn it over to the experts in this field. But before I turn this over to Jason Mills and Allison Brazier here, that will be able to walk you through the bill and our proposed amendments to those bill, which are actually pretty significant. I just wanted to give you a little background on why I feel like this bill is important and how it kind of came to be. For me, in addition to being a member of many book clubs where I'm reading anything from fiction to autobiographies, I also tend to be a nerd, and I can't quit being a lawyer, and I read a lot of Supreme Court decisions that come down. And one came down in September of last year, and while I was reading it, what stood out to me is there was existing case law precedent that had been in effect for nearly 40 years. And within the context of this opinion, there was a line that was, the legislature should have taken this on responsibility on. So at that point, that's when I decided to file this bill. And what you see before you is some work that came from the last 40 years, as well as the work that is done in this very detailed, intricate area of complex law and a combination of workers' compensation and tort law, where they all kind of meet and collide and make everything very confusing. And with that, I will turn this over to my two co-presenters to walk you through the bill and the amendments.
Thank you, Senator Wynn, and for this committee for hearing this important bill that's going to help clarify this weird legal limbo that we're in right now. So Allison Brazier for the record on behalf of Nevada Justice Association. I want to just talk to you first about the types of workers' compensation cases that this would affect, and then give you a little bit of history about how we got here, and then Jason's going to walk through the bill. And the way we're going to present today is with the proposed amendment that we've been working with stakeholders to come to. So the types of cases that this bill would affect are a very unique subset of the workers' compensation cases. They're when the PI tort world intersects with workers' compensation. So you've got good employee, good employer, and then you've got a third party tortfeasor who causes harm to the employee. So some examples of that would be a police officer who gets rear-ended while he's on duty, a plumber who gets bit by a dog when he's in a customer's house, a valet who gets hit by a car as they're, going through the driveway at a casino. So good employee, good employer, third party causes the harm are the only types of workers' comp cases that this bill would affect. And in 1986, the Nevada Supreme Court came out with a case that we refer to as Breen. And the Breen case created a formula for how we deal with those third-party proceeds when we do have a workers' compensation lien involved with the PI case. And that formula created an equitable distribution of the procurement costs for that third-party case, and distributing those costs between the claimant and the insurer. And that's how everyone had been operating since 1986 when that case came out. There's been 19 legislative sessions since 1986, and legislature has never intervened or made any changes to that formulation. In 2017, a case came out called Paremba that distinguished the significant differences between the damages available in the tort world and the damages available in the work comp system. That put a little bit of a wave in how we started doing the calculations, but again, everyone continued working between the Breen formula and then what the Supreme Court gave us in Paremba. Then in September of last year, what Senator Wynn was referring to, the Vasquez case came down from the Nevada Supreme Court. And in Vasquez, the Nevada Supreme Court looked at both Breen and Paremba. They did not say those cases are wrong or that those formulas were wrong, but they said this is a question for the legislature to answer. This is not for the judiciary to decide how these proceeds should be divided. So that is why we are here before you today, is to create a solution and put back a predictable system, again, when the work comp and the tort worlds collide. When we were drafting specifically the amendment that you have before you today, we were looking at some of the criticisms of Breen and Paremba, that there was always a little bit of element of uncertainty and complexity into how the formula worked and different factors that might affect the outcome. So what you see before you in the amendment is very similar to what would happen under the Breen formula, but we feel like this bill simplifies that a lot, and it gives predictability for everyone involved, the insurers and the claimants, regarding what happens to the lien for benefits that have already been paid, and then what happens to benefits that may potentially be paid in the future. And so again, the goal when working with stakeholders was to simplify the formula and to give predictability to everyone involved in the system. And I'll let Jason walk you through the bill and the proposed amendments, how that would all work.
Thank you. Jason Mills on behalf of the Nevada Justice Association. Chair Scheibel, I appreciate you and the entire Senate Judiciary Committee for hearing this bill today, and I would like to thank Senator Wynn for bringing this much needed legislation. I would also like to indicate that we have been working diligently with the stakeholders in this particular space, particularly the large insurers, large employers, self-insureds, and gaming, to ascertain what would be the most equitable, fair, and yet efficient and predictable way in order to distribute limited funds that are recovered in the tort system. If there were unlimited funds, of course, none of these statutes would be needed, right? Because everyone would be made whole, the insurer would be made whole, the claimant would be made whole, there would be no issue. But the reality is in most tort situations, there is not sufficient coverage to deal with the actual losses and to deal with the workers' compensation lien. So that's where the discord, or that's where the disparate points of view and interests are happening, right? Limited funds, multiple parties claiming towards it. That is what this law, 616C215, deals with. That's what this amendment deals with. That's what Breen and Paremba dealt with over the last 40 years. The bill that's in Nellis is our original draft. We have met with the stakeholders in the industry and substantially altered that. We've effectively removed everything that's in the original bill. So everything in the original bill, you can throw in the shredder. The proposed amendment, which is before you, I believe it's been circulated. At the top, you'll see it's entitled SB 258, Proposed Changes by the Nevada Justice Association, 3/25/2025. What we've done in this is, rather than use the LCB version of orange and double underline and red and all that, we just took the existing law, 616C215, and just dropped in blue changes to those. So you can just see exactly what this bill would do. And that is effectively this third page where only the blue writing is on it. That is the full extent of the current proposed version of SB 258. What it does is, under Section 7 of the statute, it effectively indicates that the industrial insurer has the right to recover the lesser of either the entire lien or 1/3 of the total recovered funds from the third party. So what this is contemplating is the scenario where there's not enough funds in the third party claim, right? Which is the majority of scenarios. If there is enough funds, then the industrial insurer will receive the entirety of their lien. But the reality is most work comp PI crossovers, PI for personal injury, deal with the scenario of automobile accidents, usually where a worker is driving, a police officer, construction worker, you name it, anyone who's driving for their work. And if they're hurt or harmed by a third party, they're typically driving around with the state statutory minimum policies of $25,000 coverage, which means then the majority of these cases that we're dealing with are often dealing with these $25,000 limits. And sometimes we're dealing with more broader limits of $50,000 or $100,000, but the vast majority of cases fall into those realms there. So what this does is it recognizes there's limited recovery. Where there's not limited recovery, then the entirety of their lien they're entitled to recover. The next portion, subsection 7A, indicates that there's the reality of costs, the procurement in order to obtain these recoveries. Of course, the third-party tortfeasor doesn't just typically say, here you go, claim it. Thank you for, bringing an action against us. It usually takes amount of time, effort, in order to recover those funds. The Breen and Poremba cases dealt with that particular issue through formulas, et cetera. In this particular situation, we've discussed with the stakeholders, and we're like, well, there's two parties that are recovering, so splitting the cost, 50% of the cost of procurement should be included against the lien. Now, one of the problems with the existing case law, Poremba, was it didn't indicate whether or not, when the parties would allocate how those funds were set forth, any weighted to challenge that. So parties were constantly concerned if someone was trying to game the cost factor. So we realized that request that the insurers and employers made, and we said, okay, well, if that's a concern, then let's put language in there that it is expressly reviewable if you believe that the costs are incorrect or problematic, and you can ask a district court to have jurisdiction and review those costs. So the problems that were coming out of the old Poremba case are addressed with this particular provision here, which was a concern of the stakeholders. The section 7B has to deal with what we call is future offsets. What are we talking about there? In workers' compensation cases, they're not like personal injury cases. In a personal injury case, when your case is over, you typically sign a release or a jury gave a verdict and the case is over. In workers' compensation in the state of Nevada, the claims are reopenable for life under certain situations. This means down the road that a claimant could reopen his or her claim. This is existing law and has been our law for as long as I know. I've been practicing 25 years. We've been doing workers' compensation law in Nevada since 1911. So reopening has been part of our statutes since the beginning. What this deals with is what happens when the case reopens. Now, the money in the personal injury has already been distributed pursuant to the earlier sections here, correct? That would have maybe been years earlier. The money was recovered. The industrial insurer gets some of the money. The claimant gets the remainder of the money. They split the costs. But when the claimant goes to reopen the case, because their condition might have been so bad, and the tort claim was limited in its recovery, what do we do with the offset? Meaning the industrial insurer is like, well, you claimant recovered some more money that you personally put in your pocket. How do we deal with the fact that you got those funds? And now we're going to be exposed to more additional exposure, which is part of our law, whether there was a personal injury case or not, right? This isn't unique in personal injury cases. This is all workers' compensation cases. So what this section deals with is, in the future, if their case is reopened or there's future benefits that are owed, this would allow the industrial insurer for the indemnity payments that they owe. For example, when they're on short-term disability pay, I'm going to make up the number, they're on short-term disability pay for $3,000 a month. That's what they're being paid while they're recovering, going through surgery, et cetera. This would allow the industrial insurer to lower by 1/3 the payment to the claimant in recognizing the fact that he or she did recover tort money months, years, decades before. And it would allow them, the insurer, to offset the payments to the claimant until every single dollar that the claimant received, that he or she personally received, was completely offset. This strikes a balance between the two parties because of the reopening rights right now under the existing rules, and Poremba had dealt specifically with this issue, is now not allowed to be dealt with under our existing rules. So a claimant cannot reopen their case, and they could have substantial injuries even if they had a small recovery until they spend every single one of those dollars. That's a problem. That's part of the problem of the reversal of the Poremba case. So this section here recognizes the reality of the claimant's right to reopen that we have in this state and we've had for many, many, many decades, but also recognizes the insurer's right to reduce their financial burden while accounting for every dollar that the claimant received in his or her personal injury case. Lastly, Section C dealt with one of the concerns that was raised was, what if the case goes to trial, the personal injury case goes to trial, and there's a huge award of attorney's fees and costs? Shouldn't we be able to share in those as well? Sure, we're not trying to hide anything. Every dollar that's recovered in the third-party claim would be subject to this section of the law. That is what this bill does. That is the full extent of SB 258. It addresses the realities and the concerns of the two parties, the insurer and the employer, and the claimant, and the limited recoveries in the personal injury tort scenarios. And this strikes a balance between those competing interests where both the insurer and the employers are looked at, but also the claimant, the actual injured party, the person who is maybe harmed for life, is also taken care of by this particular change. Thank you for your time. If there are any questions that you have of myself or Ms. Brazier, we're happy to address them. Chair Scheibel.
All right, thank you so much. I think we do have a few questions. I will start with Senator Orenshaw.
Thank you, Chair. My question either for Mr. Mills or Ms. Brazier. The amendment as proposed, would it affect a workers' comp case if there's not a third-party tortfeasor that caused injury to that worker? Would it affect, the normal workers' comp cases where there's not that third party that caused harm?
Through you, Chair Scheibel, to Senator Orenshaw.
Please go direct.
Good, I'll go direct. Jason Mills on the Nevada Justice Association. Senator Orenshaw, no, as Ms. Brazier indicated earlier, this statute, the Breen case, the Poremba case, the Vasquez case, and this statute and this bill only deal with scenarios of an employer, an employee, and a third-party tortfeasor that caused the harm. It impacts no other workers' compensation case in the state.
Thank you for clarifying that, Mr. Mills. Thank you, Chair.
Other questions from members of the committee? Okay, go ahead, Senator Krasner.
Thank you, Chair. I just have a quick comment. It's really hard to believe that we would ever have a case where the injured claimant is not included in the division of the award. So thank you for bringing this case.
Thank you. And then I do have one question, and I don't want to open a can of worms because I'm sure that you've discussed this with all the stakeholders, but I'm curious what's going to happen to this, what is it, a year's worth, not even, a couple months worth of cases that were adjudicated, settled, or handled in between the overturn of the Breen decision and the passage and approval effectiveness of this bill.
Allison Brazier for the record. I think the reality of what has been happening since September is that a lot of these cases either have gone before the district court to decide how the funds should be dispersed, or they're kind of in this limbo state where, no one is sure what should happen. But I think the vast majority, Mr. Mills, probably has a lot more experience than this because his primary specialty is workers' comp. But a lot of them have gone before the district court because there is this, since September, uncertainty in how the fund should be dispersed.
Jason Mills, Nevada Justice Association, Chair Scheibel. To mimic what Ms. Brazier was saying, that's correct. There is great confusion going on right now. In the district courts, we're getting different decisions from judges that are completely opposite of one another. One ruling one way, another ruling another punting, some taking jurisdiction, others kicking jurisdiction. It is a mess. The good news is under subsection 2 of this statute that we've indicated that this would apply on the effective date of this act would attach to any case where there's the final settlement, judgment, or disposition has not been entered on the effective date. So we believe that this should attach to those and help in the fights that are going on in the courts that we've been left with in the wake of no Breen, no Poremba, and the Vasquez that just said, fights on. So basically, we think that when this goes through with the language in Section 2, this will greatly help calm all the parties and all the parties understand with this certainty and predictability with what Allison was bringing up earlier, Chair Scheibel.
Thank you. And that does, I think, answer my question. And I don't see any other questions from the committee. So thank you so much for your thorough presentation. We will move now to testimony. We'll start with testimony in person in support of SB 258. Anybody wishing to give in-person support testimony here in Carson City is invited down to the front tables now. In case any of you haven't been in this room yet, the buttons for the microphone look like a little sticker that was dropped on the table. And when the microphone is red, that is the time to speak. So please go ahead whenever you're ready.
Hi, Kaylin Cardavani, Kaylyn Kardavani, on behalf of New Day Nevada. We are an economic justice organization, and we appreciate this bill because we think it is fair and brings a lot of justice. So, yay.
There we go. Can you hear me now? All right. Thomas Morley for the record, representing Laborers Local 872, Laborers Local 169, Northwest Regional Office of Laborers Union, CWA, Teamsters 631. We are all in favor and support. Thank you.
There it is. Oh, wait a second. Sorry you said that. Good afternoon, Chair Scheibel, members of the committee. My name is John Abel, spelled Johnabel, and I represent the LVPPA, representing the brave men and women who serve and protect the citizens of Nevada. As law enforcement officers, on behalf of our membership, I'm here today to offer our strong support for Senate Bill 258, a measure that brings much-needed reforms to the state's industrial insurance system, particularly for injured employees, including our officers who put their lives on the line every day. Law enforcement is an inherently dangerous profession. Our officers face unpredictable risk, physical assaults, vehicle pursuits, and exposure to hazardous conditions that can result in serious injuries and tragically death. The industrial insurance system, as outlined in the NRS, A safety net for our members and their families when such incidents occur. However, the current framework has limitations that can leave injured officers and their dependents unfairly burdened, especially when seeking additional recovery for third parties or underinsured vehicle coverage. Senate Bill 258 addresses these inequities, and we believe its passage will better protect our members and ensure they receive the full support they deserve. Thank you.
For the record, Ryan Beeman representing the professional firefighters in Nevada. Thank you for the opportunity to speak in support of SB 258. I urge strong support for this important piece of legislation. Supporting it is not just improving our industrial insurance, it's also standing up for the hardworking individuals who drive our economy. It also helps with the Nevada's priorities with the health and safety of this workforce. I urge you to vote in favor of this measure.
Good afternoon, Chair, committee members. My name is Harrison Porter, Harrison Porter. I'm here representing the LV PMSA, the Supervisors of Metro, and just want to say ditto on everything John Abel said. Thank you.
Good afternoon, Chair Scheibel, committee members. Jason Lesher with the Washoe County Sheriff Deputies Association. Also a ditto for our colleague John Abel's comments. Thank you.
All right, I don't see anybody else coming forward to give in-person support testimony. So we will go to the phones, please, for support on SB 258.
Thank you, Chair. The public line is open and working. However, there are no callers wishing to provide testimony in support at this time.
All right, then, we'll go to testimony in opposition. Anybody wishing to give opposition testimony in person is invited up to the front here in Carson City or down in Las Vegas now. Go ahead whenever you're ready.
Good afternoon, Chair and Committee. My name is Sabrina Schnur, Sabrinaschnur. I'm here today on behalf of the American Property Casualty Insurance Association. We've submitted a letter highlighting our concerns, and we were opposed to the original bill, but we haven't had a chance to review our new amendment yet, so I will halt my opposition there for now. Thank you.
Thank you, Chair Scheibel, committee members, Misty Grimmer, GRIMMER, representing the Nevada Resort Association. Work comp thankfully continues to be, knock on wood, one of the arenas where each session the parties are able to sit across the table from each other and reach a compromise. Seems doing that in the legislative process has become rarer and rarer. Or it might be because everybody's eyes glaze over when we talk about work comp. I'm pleased to report to the committee that we have had very productive conversations with the NJA on SB 258, conversations that have included employers and insurers. We are here in opposition today because those conversations are still ongoing, but we are very close. Mr. Mills and Ms. Brazier, of course, did a great job explaining the nuances of what SB 258 addresses and what brought us to this point. It is a complicated issue, made more so because what we're talking about is the crossover between a no-fault insurance, which is workers' comp, overlapping with tort claims, which are about assigning fault and holding the third party accountable. It's important to keep in mind that the employer or insurer have already outlaid the cost of the worker's medical care and most likely indemnity payments and additional medical costs that will go into the future. SB 258 and the concept of subrogation is about finding a fair way to help the employer or insurer recover those costs when a third party was at fault for the injury being caused in the first place, yet also providing an incentive for the injured worker and their attorney to bring the tort suit in the end. We look forward to continuing our conversations with Senator Wynn and the NJA to bring back to the committee a bill that comes as close as possible to finding that perfect balance for the courts to follow in these cases. Thank you.
Good afternoon, Chair Seibel and members of the committee. My name is Dalton Hooks, Hooks, appearing on behalf of the Nevada Self-Insurers Association. In a way, along with Mr. Mills, I'm kind of responsible for this being in front of you today since it was my firm that litigated this case. I just want to be clear on where we are and how we got here. There would never be a case where the claimant would not receive recovery. What we're talking about in these cases, a third party is responsible for the injury to the claimant. And In the case underlying this decision, the Vasquez case, the reality was that the district court said, because of the formula from Breen, which has never worked for the 45 years that it's existed, if I were to hold you to the existing law now, not only would you not get anything back on the monies that you have spent, in fact, you would be paying money towards the cost to get it. And that was the reality, and that's how we ended up in the Supreme Court in the first place. So the Vasquez was a case that was decided based on going back to basics. You folks do legislation, and the courts don't do that via fiat, and that's what they were saying. In any case, I entirely agree with Mr. Mills. He has been working diligently. I have had many discussions with Senator Wynn, and we are all working towards an equitable way to address these third-party cases. We are close. We have only had the language that we now have before us for approximately 24 hours, maybe a little bit less than that. I am encouraged that we are going to be able to reach that destination of equity, and that's where we're headed. So for now, the NSIA is opposed, but we are working diligently towards getting this done.
Good afternoon, Chair Scheibel. Jesse Wadhams, for the record, representing the Vegas Chamber. We are currently opposed at this time, but obviously, as you have heard multiple times, there is a lot of progress on the amendment. The Chamber just wants to make sure that the process for these complex suits, the third-party subrogation, and these processes are all fair, and again, look forward to working with the parties as they continue their discussions. Thank you.
I'm not sure your microphone's on. Is there a red light?
How is it now?
There we go.
It's flashing red. Chair Seibel, members of the committee, my name is Charles Nort, N-O-R-T. I represent Nevada Alternative Solutions, iGaming, and TNR Painting Construction Group. We were opposed to the original bill as SB 258 as drafted, but now that Mr. Mills has said it's in the shredder, I'll turn to the amendment, which we just received also. But I've been talking with the parties and the stakeholders, specifically Mr. Mills, and also the proponents with respect. We've made great progress. As a matter of fact, as I look at this, Section 7, as Mr. Mills has alluded to and presented to the committee, it reflects most of the proposal that I had in mind to begin with in discussing this with them. So I'm very pleased to tell you that we made great progress, and I will continue to work with all the stakeholders in doing so. I'm confident we can come to a final amendment on this that will represent the interests of all concerned, including the claimant. And from that standpoint, I stand with all the stakeholders to continue this and wordsmith it in any way we can and bring it to a final conclusion. Thank you for your time.
Chair Scheibel and members of the committee, my name is John Noble with Employers Insurance. We're the largest workers' comp insurer headquartered in the state of Nevada. Like others, I had some nice opposition testimony ready for the previous version of the bill. But I'd just like to say we really appreciate NJA working with us on this. We've had a lot of productive conversations. I think we're really headed in the right direction. So I think we're a soft opposed right now, if that's allowed. And just really appreciate y'all scheduling this in your time today. Thank you.
Thank you, Madam Chair, members of the committee. Alexis Motorex with the Nevada Chapter Associated General Contractors. We just want to thank the Nevada Resort Association and the Chamber for the work they've done on this with the NJA and sponsor. We share the concerns that they have articulated and look forward to reaching that compromise. Thank you.
Brian Wachter, Senior Vice President of the Retail Association of Nevada. Good afternoon, ma'am. We also are in opposition. We'd echo the comments of the Vegas Chamber and the NRA, and we look forward to the ongoing conversation.
Good afternoon, Madam Chair, members of the committee. For the record, I'm Paul Enos, Nevada Trucking Association, also opposed to the bill as drafted, but as stated previously, we look forward to a resolution through the negotiations that are happening. Thank you.
There we go. Good afternoon, Madam Chair, members of the committee. For the record, Andrew McCam, the Executive Director of the Nevada Franchise Auto Dealers Association. I'm not going to add anything substantive other than As somebody that's a member of NSI, I want to thank obviously Mr. Hooks, but as importantly, NJ and Mr. Mills and his team on what we believe is a bill that we're 95% there. So I just wanted to put that on the record and thank all parties involved.
All right. Yes, absolutely. Soft opposition is allowed, and I do appreciate the spirit of cooperation that we're hearing today in testimony. I don't see anybody else present to give opposition testimony either in Carson City or Las Vegas, so we'll go to the phones for opposition testimony on SB 258.
Thank you, Chair. The public line is open and working. There are no callers at this time.
Okay, then, we will go to neutral testimony on SB 258. Anybody wishing to give neutral testimony is invited forward now. I don't see anybody coming up in person in Carson City or Las Vegas, so we'll go to the phones for neutral testimony on SB 258.
Thank you, Chair. The public line is open and working, but there are no callers at this time.
All right, then that brings us to the conclusion of testimony. If the presenters have any final remarks, we invite you down to the front table now to finish up.
Allison Brazier for the record. I just wanted to quickly address something that came up in the opposition, also to go back to Senator Krasner's comment. Under the current state of the law with the Vasquez case, there are definitely situations where the injured worker would get zero. And so that's why we've brought this bill, so that we can fix that problem. We feel like it simplifies the process, it clarifies it, and brings predictability to everyone involved. Again, like you heard, we've been having a lot of ongoing conversations and good compromise going on, and so we look forward to continuing those and getting that 1% more so that we can get all the stakeholders involved on board with the amendment.
Chair Scheibel, Jason Mills for the record. Again, I would like to thank you, your entire committee, and Senator Wynn for hearing us today and bringing this bill, and the parties that were in opposition. I do appreciate their coming forward and discussing frankly with you that, as most of them said, they were in soft opposition. We have been listening to what they have said. We have been diligently working to get to a compromise situation that makes sure all parties and interests are addressed, particularly the injured worker as well as the insurer, but again, realizing there are limited funds in these third-party recoveries. That's what we're dealing with. When there's plenty of recovery, this is not an issue. Majority of the time, there is not. So again, thank you. We appreciate your time, and we'll continue to diligently work, and we look forward to bringing you a bill that we can see walk right out of the building with no opposed. Thank you.
Thank you so much. With that, I will close the hearing on SB 258. And that takes us to the last item on our agenda for this afternoon, which is public comment. Anybody wishing to give public comment in person is invited up to the front now. I don't see anybody coming forward to give public comment in person in either Las Vegas or Carson City, so we'll go to the phones, please, for public comment.
Thank you, Chair. The public line is open and working, but there are no callers at this time.
All right, then that brings us to the conclusion of our meeting for today. Thank you all for being here, and we are adjourned.